military justice and the law, presented to you by Bulani Tsiu. In this episode, I'll be discussing the military court system of South Africa, as well as the jurisdiction of these courts. Section 6 of the Military Discipline and Supplementary Matters Act 1999 establishes the military court system comprises of the Court of Military Appeals, the Court of a Senior Military Judge, Court of a Military Judge, and the Commanding Officer Disciplinary Hearing. The establishment of these courts came about as a result of the need to harmonize the military court system with the new culture of constitutionalism. It must be remembered that before 1999, there was a court-martial system in South Africa which was found wanting when it was tested against the constitutional principles. So it had been hoped that with the establishment of these courts, concerns that were raised regarding the abolition of the court-martial system would have been put to rest. But we'll see if that is indeed the position. The military courts in South Africa have jurisdiction basically to try soldiers. However, some civilians who are connected to the military by reason of being contractors, who travel the military, with regards to certain operations, such persons can be tried by our military courts anywhere in the Republic, by reason that our military courts enjoy what lawyers call extraterritorial jurisdiction. In other words, their jurisdiction extends beyond the boundaries of the Republic of South Africa. And in such courts, soldiers can be tried for various offenses, common law offenses, for example, your murder, your rape, your cannibal homicide, if they are committed outside the borders of the Republic of South Africa. However, no military court has jurisdiction to try a soldier for murder, rape, cannibal homicide, and treason that is committed within the borders of South Africa. So that is the limitation basically to the military courts. Furthermore, proceedings in the military courts are conducted in a formalistic manner. By that I mean, unlike with regards to civilians, soldiers must wear their ceremonial dress. Escort usually will also wear and must wear the headgear. However, the accused person does not wear headgear, although he's also dressed in a ceremonial regalia. The accused will ordinarily be given his headgear back if ever he is acquitted in court. So now coming to this particular court, the Commanding Officer Disciplinary Hearing. It is classified as a court, but when one looks at the practicalities of its operations, one sees that it is more of a disciplinary hearing than a court of law. Commanding officer disciplinary hearings are presided over by commanding officers. This is to be expected considering that officers commanding are responsible for the discipline of men and women under their command. Presiding officers in the commanding officer hearing usually are persons who are not trained in law. The MDSMA simply requires that that person must be a holder of a field rank, and he must have been delegated by an officer commanding if he himself is not an officer commanding. So a field rank basically is that a rank that is not lower than that of major or lieutenant commander. So not every soldier is entitled to appear in the commanding officer disciplinary hearing. a soldier must hold a rank that is lower than that of a warrant officer, meaning which he must be a staff sergeant or equivalent and below, and must have committed a military discipline offense. In other words, an offense that is punishable by imprisonment, not exceeding a year. That person must have intended to plead guilty, because in that forum, not guilty pleas are not entertained, and the accused in that particular forum does not have the right to be represented by a lawyer. The prosecutor in that forum is an adjutant who is a person responsible for disciplining the unit, but he or she need not be a legally qualified person as well. So now the problem that arises in this regard is that when the accused appears before the commanding officer hearing, the commanding officer may put questions to the accused, and the accused person basically, can give those responses. So the lack of a legal qualification may be an impediment for that commanding officer to appreciate whether the responses given by the accused person in fact amount to defense in law. So that is the issue that I'm having in that court. Court of a military judge is presided over by a person who holds a rank of a lieutenant colonel or major or the equivalent. And they have jurisdiction to try most offenses as well, that are contained in defense legislation and legislation as well as in common law, but may not impose imprisonment exceeding 2 years. And with regards to person, their jurisdiction is limited to basically persons who hold a rank that is lower than that of major. In other words, a court of military judge does not have authority to conduct trials of field officers. That court may sit with or without assessors. Assessors are persons who may assist the court on the questions of fact, not of law, because questions of law are reserved for the court. Questions of fact in case the court is not basically knowledgeable about a particular specialized skill. So assessors come into play in that regard. So with regards to the court of military judge, the presiding officer there must hold a rank of colonel or equivalent and above. And that court has basic jurisdiction over all soldiers. And that court may impose severe penalties, including imprisonment for life. So with regards therefore now to the Court of Military Appeals, the Court of Military Appeals is classified as the highest military court in the land, and it has both review and appeal powers. Section 8 of the MDSMA makes it clear that the Court of Military Appeals may vary sentences, set aside findings, or basically set aside even sentences. But importantly, it must be known that the composition of the court is that in a matter that involves murder, treason, rape and criminal homicide, it is basically presided over by 3 judges of the High Court or 10 judges or magistrates. And one other member must be a military practitioner with extensive experience, and another member must be basically an officer who has a combat or operations experience. The issue now with this court is regards to the role of this other person who is not trained in law, the one who provides operations experience. Yeah, I'll return to that. But in any other case which does not involve those offenses such as murder, the Court of Military Appeals may be presided over by 3 persons, of which the chairperson must be a judge of the High Court or retired judge or magistrate. And the other 2 persons, one must be a military practitioner and the other one must be a line officer with a combat operational experience. Now, Well, the question therefore really is, what is the role of this other person who does not have a law degree but he has operational experience? Section 89 of the MDSMA, rather Section 89 of the Military Discipline Code, the MDC, stipulates that the findings of the Court of Military Appeals depend on the vote of its members. In other words, all 3 members participate. This is contrary to what was said in Dimakwe versus President of the Court of Senior Military Judge, because that court said that person's role is to assist the court with basic experience with regards to military culture and experience. That person does not contribute to the questions of law. However, that's not true, because we know that that person contributes on the question of law. He can vote. There are decisions where that person, went beyond voting, even prepared and delivered judgment. In State versus Machad, the CMA, or the Court of Military Appeals, dealt with a matter, an automatic review of a matter of a captain who was basically sentenced for various offenses. Now, this captain was basically reduced to the rank of lieutenant by the trial court and the suspended period of imprisonment. And by virtue of that suspended imprisonment, the matter went to the Court of Military Appeals. A member who is not trained in law prepared that judgment. And what is strange is that the chairperson, in other words, the High Court judge, agreed with this person who's not trained in law. The military law practitioner in the matter delivered a minority judgment per se. As a result, the sentence of Machad ended up being increased to that of Keshari as a result of the influence by this military member who is not trained in law. Is this constitutional? One must remember that the Constitution says that judges must be people who are appropriately qualified. Although it does not specifically say that you must have a legal qualification, but to be appropriately qualified entails that a person must have a legal qualification. So essentially, if one has to look at this person without legal qualification, will find that he is found lacking in many respects. So in this connection, there are concerns with regards to the Court of Military Appeals integrity as an appeals court. So it would be best if ever the composition of the military appeal can basically be made to basically comprise of people with legal qualifications, as is the position with regards to other countries' military courts of appeal, for example, Canada and the United States of America. So we can learn from those countries and establish a similar thing. And that will require an amendment to the MDSMA to give rise to that effect. Because as things stand now, the Court of Military Appeal really is problematic. So in this episode, I explained the military court system, outlined the military courts that exist, and I've basically explained the shortcomings that are there. So one must remember that military courts have a constitutional status, because if one reads Section 166E of the Constitution, makes it clear that courts that are recognized in the Republic also includes those that are established in terms of legislation, which in this case, the Military Supplementary Measures Act. So I trust that you enjoyed this episode. Whoever hasn't subscribed, please subscribe. In the next episode, we'll be basically talking about some offenses and punishment that raises concerns. Until next time, thank you.